Hi, I'm Tom Martin. I'm the CEO and founder of LawDroid, and we're a company dedicated to helping lawyers supercharge their law firms with the help of AI legal assistants that can help with everything from case law research to analyzing documents to even capturing new leads. The session you're about to watch first aired live at LawDroid's first annual AI conference. One thing I would ask of you is to please keep in touch with us. You can subscribe to LawDroidManifesto.com, which is a newsletter where I can keep you updated about the latest developments in law and technology, and let you know about great events like this that'll keep you informed and that you can walk away from with actionable intelligence. Stay tuned.
Hi, all. Now that I've moved to North Carolina, I can say that with impunity, right? Um, I'm Catherine Sanders Reach. I'm the director of the Center for Practice Management at the North Carolina Bar Association. I was in Chicago at the ABA and the CBA for 20-something years before that. And so I'm going to kick it off. But Carolyn and Joshua, do you want to go ahead and introduce yourselves?
Oh, Carolyn, I can't hear you. I'll go while you figure that out. Hi, everyone. I'm Josh. I wear a number of hats, professor, advisor, but most of you might know me from Brainiacs, which is the twice weekly newsletter on the pragmatic use of AI. I've been writing that almost going on a year, 165 editions. So it's great to join you guys here today.
Okay, am I on now?
Yes.
Okay, I pushed that stupid button on the mic. I'm Carolyn Elefant. I own an energy law firm in Washington, D.C. I'm also the owner of myshingle.com, which is the longest running blog on solo and small firm practice. And in the past year or so, I have become I can't think of the word, but I've been speaking a lot on AI to bar associations and lawyers across the country. And I also hosted a program on using AI to start and build your own law practice with artificial intelligence as your digital partner. So I'm glad to be here. And I guess Catherine's going to kick it off.
Indeed. And I guess, we've all been drinking from the fire hose. Josh, it feels like I thank goodness for Brainiacs, because otherwise I would spend more time than I already do trying to keep up with the stuff. I think I subscribe to 45 different newsletters, and then I have to go and test them, because in my work, what I'm trying to do is help lawyers pick good tools to get their jobs done, whether that's artificial intelligence or, something very bread and butter like Proton Mail or whatever. So going through and looking at all of this, I tend to start writing lists. So listen, and then kicking tires. But one of the things I wanted to kind of start out with, and I know y'all have some good caveats and things to think about, but as I've been going through and playing with these different tools, not all tools are equal to the task. Either I'm not very good at writing prompts, or I'm too, I guess, demanding on what I really think the tools are going to spit out. So I'm very excited about things like the GBT mentions, so that you can start stringing together tools that give you the actual output that you're looking for, and not having to move from one segment to another tool to get the actual output. To give you for instance, I had a document buried within, it was a timeline. I had the timeline extracted, then I wanted to take the timeline and make it visual, but I had to use two different tools to get that to happen. And so I'd like to not have to do that. So that's what I'm waiting for. And I know there's probably some purpose-built tool out there, but I haven't found it yet that was really going to give me what I wanted it to do. But I've kind of divided these things up into free personal, and then general business, and then kind of purpose built that it does one thing pretty well, and then kind of the legal. So seeing tools like Copilot and VLEX, knowing that those are more general legal solutions to problems. But even things like we were talking when we would have our conference call to talk about this, Claude versus Perplexity versus Chat GPT. And then I use Bing Chat Copilot, the 365 business version, which they were calling Enterprise for 5 minutes. And and that's the other thing. They keep changing the names. That doesn't make life any easier. All of those things I use on a daily basis. I chat with Bing in my car. Because I can ask it questions as I'm driving along, and I think that's great. But then we move into that general business category, and that's like Microsoft Copilot, or some things like there's a product called Clarify that will let you go through and auto tag or take a huge set of documents or images and comb through it looking for what you want, with pattern matching. There's a tool that I've been playing with called Numerous AI, and it's Chat GPT as an add-on for an Excel spreadsheet. So you can ask your data questions. And that I think is interesting because it gets us into this whole client notification ethics issue, and what happens if I upload a document into Claude? Where does it go? Who has access to it? And I know you're all going to speak to that a little bit. I've heard that it's been suggested that if you're going to upload a document that has client information, that you could sanitize the document before. But I just like to see the tools, I guess, get grown up enough to where we have a little bit more trust about what's going to be done with that information, and a little bit more transparency on that end, one way or another. So yes, somebody just posted in the chat risk. So we're talking about weighing risk, and but when you're looking at functionality like summarization, it's awfully convenient to be able to upload a couple of documents and say, pull the key points out of this, and that kind of thing. So down the road, it's going to be helpful to know what are they doing with the information that we're uploading. And then we've got all these purpose-built tools that are, dealing with contracts. I've been using Hemingway for writing, but again, what are they doing with it? Because I'm copying and pasting into Hemingway. What is that where's that information going? Firefly, have y'all used Fireflies for so Fireflies is a tool, and I've used a whole bunch of different ones for recording video conferences and then running the automated transcription and summaries. And I've used Fathom and Tactic and the built-in with Teams and the built-in with Zoom. And I think Fireflies is my favorite one out of all of them in terms of the actual output, which is why I've been, again, just kicking tires on all these things, seeing kind of where rubber meets the road in terms of reality. And then getting into the legal products. So Lexis and VLEX and LawDroid. There's a tool called Regology that has this product called Reggie, and it's regulatory tracking. So they have regs from all over the globe. You can sign up to get updates from it, but you can also query this regulatory database using AI. And Joseph and Ontro and Visa Law, shout out for the immigration lawyers, and Next Chapter as well, because both of them are leveraging that tool, Harvey. So there's a whole lot of different tools, and I feel like it's important to know which tools do what well, and that many of these are still in what I would call a beta. Whether they are actually calling themselves in beta or not, I think there's some maturity that we have yet to see, in both functionality and interface and transparency in terms of, is this safe for lawyers? And somebody just mentioned that they use Otter AI, and I like Otter too. Anyway, so I guess at this point, I have a whole lot of things that I listed out that you can do with these tools. And there's another session on the business of law. So we're really focused on the practice of law, what you can use artificial intelligence tools to do in the practice of law itself. So going through, obviously summarization is a huge one. Just being able to have it read through numerous documents or lengthy documents and coming up with an outline or a summary or an executive summary is very helpful. But you have to ask the question, do you have the knowledge to know if the answer is right? So I think one thing that I've done is experiment with my own content. So taken my own content and said, generate a summary of this. And sometimes it's pretty good. And sometimes it's like, well, if I were going to do it as the author, they've missed some essential points. But then I've gone in and done guest lecturing for different universities, and we have been testing artificial intelligence tools. And so I usually ask them which tool they want to use. And then we ask it to generate a biography of their professor. And it's, it seemed pretty on point until it does things like give someone an erroneous PhD from Berkeley. So, and why it does that, I don't exactly know. I've had good experience with it writing letters and checklists and outlines, pretty decent timelines. The things that I get excited about are the ability to expand on knowledge management activities in firms, being able to use tools like Joseph to kind of look at all of the policies and documents and be able to get information out of that without having to read through. The search tools just aren't good enough. So I'm excited about the application of that. And then things like monitoring, do you have a contract that, all the contracts that are going to be expiring, and having it monitor and say, okay, popping this one into your field of vision based on expiration, or that a reg has changed, it's going to need to change this clause and that kind of thing. I think all of that has some really exciting application. And then of course, discovery and e-discovery has had machine learning and artificial intelligence built into a lot of tools for years, and that's just expanding. So I guess, do y'all feel like a lot of this stuff is still in beta?
100%. 100%. There's few fully baked products out there, which is good. I mean, that's fantastic. And, when we turn over to me, go through how to sort of stress test those things and things to watch out for. But that's the good thing. I think we're at the early days, and we want builders. We want these products out there. The caveat is we as users have to be aware of they're not fully baked yet. So let's know where the warts are, know where the risks are, and use them accordingly.
So I think you should go ahead and start in on that train of thought.
Yeah, well, I appreciate it. Great tee up. Covered a lot of terrain there. And yeah, I'm going to spend a few minutes. If you guys want, I've got some specific, everyone wants use cases. Give me a use case. Give me a use case for this. Give me a use case for that. I think that's the wrong way. I think that's the wrong question. So I'm going to spend 2 minutes just kind of going through here. I'm going to share my screen real quickly. The way I think about it, to the extent that, this is helpful to you all in the practice of law, some actual practice of law examples. Now, quotes, practice of law. Let's not talk about unauthorized practice of law out there in every state. I mean, how we define the practice of law, I'll leave that all to you to decide. But I wanted to spend just a quick minute. Think about a use case. Don't think about that. Think about how to interact with these things. So think of them as an intern or assistant. You'll see an example down here. Catherine mentioned summarization. That's a great sort of entryway into this. I don't know what each of you are doing out there, if you're a novice, if you haven't tried them, or if you're an expert. If you're an expert, this is good review. You can also have it obviously proofread anything that you would use an assistant or intern for in your law office. Would you ask them to practice law or do something that goes towards practicing law? I hope not. So don't ask these tools either, right? The other thing that you can play with is tone. This is something that a lot of lawyers, when I sort of unlock this for them, we're really good at writing technical language, or some of us can be emotionally charged at times. We're stressed. We might not have the right tone. So we'll draft a client email, or we'll draft a response document or memo or brief even, and it might not have the right tone. And so just using these tools to like play with the tone a bit. Again, it's a nice adjustment for you. It's something that you can sort of do on the fly and very beneficial. It's not the final work product, so don't get too worried about the practice of law. The second thing is think about a coach or mentor, right? So look at the examples I use here. Like a lot of us, especially younger lawyers out there, even solos or lawyers in large firms, we're all very busy. We don't have a coach or mentor, just someone to like just spitball with. These tools can be used for this. Like, how do I make the decision? Not write me an AI use policy. You can do that too. But how do I go about making the decision for my small private company, or I'm advising a small private, and create a decision tree? A lot of this is about just clearing the cognitive dust from our brains as we task switch throughout the day. The other one down here is, stress test this SOW on lithium harvesting. Yeah. How did I come up with that? I was watching 60 Minutes and they talked about lithium harvesting and all that. And I was like, that might be really interesting. But think about it. It's a nice coach or mentor. So use these things that way. It's really powerful to unlock it. And the final one is the muse or creative. The example, you don't have to read it. There's a lot of language there. I'll just give it to you. Practice negotiation. So the hypothetical here is you're representing a buyer of a small business. The seller is kind of a curmudgeon, doesn't want to do seller financing, which means they're not going to leave money on the table. The buyer does. So you can practice negotiation with these things and just kind of refine your points, maybe uncover some unconventional points that you might want to raise in negotiations. So I wanted to hit these things because I think it's a better frame to think about the muse, the creative, the coach, mentor, or intern assistant versus specific use cases. So anyway, I hope that was helpful. Now we're going to switch to how do we sort of de-risk these tools. Now, on the right-hand side, you can go get a copy of this. Go to joshkubicki.com/checklist, and you can get a copy of this right here. Just want to sort of hit on a couple of things here. These questions, this is meant to be a down and dirty. This is not like an enterprise grade checklist to like go through every, element of a tool to make sure that it's perfect. That's not it. This is for the yous and me's out there. The people that have a heightened sense of confidentiality, a heightened sense of sort of our ethical obligations and all that. These are just nice questions that you can ask, or you can try to find out the answers to as you go through sort of vetting the tools. I'm not going to go through each one of these, just going to hit on some of the highlights. Data privacy and security. Okay, what does that mean? Who has access to what you put in and what is put out from the model? Are there humans on the other side that are reviewing inputs and outputs? Do they store it in some way? You can see the second one. If you're doing anything beyond the US and certainly in the EU, be mindful of the different data policies in the US. Obviously, we have HIPAA and others as well. What sort of is happening with that information? And can I securely input confidential information? These tools are allowing you to attach attachments. Where does that attachment reside? Catherine mentioned sort of sanitizing attachments or anonymizing these things, right? Well, where do these go? How long are they retained for? You may not get the answers, but asking the question sometimes leads you down a path to make a decision of, I'm not comfortable using this tool, or I am. For instance, I was playing around with a tool yesterday, and it wanted me to give access to my Google Drive. and Google Sheets. 100% access to read, write, delete, and copy. Freaked out. Right now, do I trust it? Maybe, but my gosh, there's no way I'm going to give it complete access. So you want to be asking these questions. The terms of use and rights, the big players are changing this all the time, from Microsoft to OpenAI to Bard to Anthropic. I try to do a good job of Brainiacs of keeping this up to speed and keeping you guys, but they change the terms all the time. You're going to see down below, there's a special call out for that. You want to understand what the restrictions are. Obviously, we know a lot of copyright and indemnification policies are arising. Microsoft is I just want to not pick on Microsoft. Microsoft has a number of products. So you might be a Microsoft 365 user, or you might be using Azure Microsoft and their AI Copilot there. Be warned, there are different terms of use for each one of those. Detangling those, put on your best lawyer hat and go deep into terms and conditions, and God bless you, because it is tough to figure out. And they're rapidly evolving, so they're always sort of changing. So do your best job there. Moving on, I just want to highlight a couple here. Usage and limitations. Every interaction, every time we press something on the keyboard and press enter, we need to know, is that counting against us in terms of how many prompts we can make with these tools? Is there a limit? Is a limit based on number of characters or tokens, complexity of the prompt, or just volume? These are just good things to know and sort of be aware of. Going to skip costs and subscriptions. That should be obvious to people. Ask those questions. And then scope and knowledge. What is the data that this stuff has been trained on? How often is it updated and retrained? And is the model open source or closed and proprietary? Now, if you don't know what open source is, I'm not going to go into a lot of it right now. There's just differences. Just be mindful that you'd probably want to know what the core model is, because there's differences in how it's updated, who has access to it, sort of all the different changes that are happening in there. The final one, I'll turn it over to Carolyn to get us into the ethical deep water. Notice of changes. I already sort of hit on this, but this is a separate call out. Try to figure out whatever provider, if you're negotiating on a subscription, you have direct access to the provider, or if it's a consumer product like OpenAI or Bard, this might be harder to figure out. But what is the notifications? If there's a change in the underlying policies, any of the things I just mentioned, how do they notify their users? Most will have a threshold. There's minor changes and there's major changes. I would argue where we are today in the market, you as a user want to be notified of every change, because what the provider thinks is minor from a user perspective, there's a big difference and a gap between that right now in the marketplace, especially in the legal profession. We sweat the minor stuff. So we want to be mindful of how they're notifying changes and all. So all good questions. You may not get the answers to them, but I've tried to sort of come up with some of the right questions to ask that hopefully helps you sort of assess the risk of using this model and whether or not it's a responsible model to use and how to use it. So with that, I'll stop sharing. And I will turn it over to Carolyn to take us into ethics and beyond.
Okay, so I'm going to try to share my screen here and see if this comes up. Here we go. So one of the things, okay, we've got my screen up there. So one of the things that you're going to have to grapple with when you start using AI in your practice is that you have control over yourself, but you're going to be working with people who you may not have control over. You're going to be working with opposing parties who you may not have control over. And there are still going to be and they may be using AI too. And so one of the things that you need to think about in terms of working in a law office is your duty to supervise and to train the people who are working with you who may be using AI, because there are a couple of things that can go haywire if you don't do that. And I hate talking about this because I hate talking about the pitfalls, not because they don't exist, but because anytime somebody hears about it, the reaction of a lawyer is to run instead of thinking, hey, I'm a lawyer, I'm trained to problem solve, so let's problem solve this problem here. So one issue that just came up, and this was prompted by what Catherine was talking about with fireflies, is increasingly people are using AI to record conversations with clients. Of course, you're going to disclose to your client that you're recording their call. That's hardly the basis for a trusting foundation with a client if you don't tell them you're recording. And my experience has been that clients really like it because that enables me to focus on talking to them, and then they get a professional looking transcript of the call after. And so they also know what they've shared with me. But I heard, and I think this was on TikTok, which is where I get a lot of good information about new developments with AI. There's an attorney who has gotten, who uses these tools to record his calls. He was on a settlement conference and he felt fairly confident that he had turned the recording device off. It turned out he'd actually been recording it. He was very ethical. He reported it to the court and had to explain what happened. But that's just one of the kinds of things that you have to tweak in your workflow once you start using these tools more regularly. If you're using AI to regularly record calls, and you have it set up to sync with your video system, you're going to have to remember, hey, when I'm on a settlement call, or if I'm speaking to an opposing counsel in a confidential negotiation, I really need to make sure to turn that off. So it's kind of a stupid low-tech reminder, but it's necessitated by our integration of these very high-end tools. So that's one of the first things. The second thing that you want to think about is not necessarily just legal or ethics issues. You also have to be kind of familiar with some of the copyright and plagiarism issues that are being litigated through generative AI. And in terms of lawsuits, things like that, as end users, I don't think there's really any cause for concern that if you use AI, that somebody is going to come after you for violating copyright. A lot of these lawsuits that you see in the paper, like the New York Times suing OpenAI, the artists suing OpenAI, those really have to do with the OpenAI platforms using content to train the devices. And as an end user, you're not really using it for training, or you're using it internally on a legally commercial machine. So that's not really something to be concerned about. But what you do have to be concerned about is if you have somebody who uses AI to produce content for you that you may want to copyright or you may want to protect, you need to know what portion of that has been developed by or has been generated by AI, because the way that copyright law currently works, and this is something that's being re-examined by the Copyright Office, but the way it currently works now is that if something is created by a machine, you can't copyright it. So imagine that you hire somebody, a contract attorney, to draft a book on family law, and the attorney you hire uses generative AI to develop the whole book. You put it on the market, and then you see that your competitor is using the book. You say, hey, what's up? And the competitor is like, oh, I know that you generated this with AI. It's not copyrighted. I can use it too. So when you have people who are working for you, whether it's associates who are part of your firm or other people who are part of your firm or people you're outsourcing to, you need to understand what kinds of tools they're using in their research in order to be able to check to verify the accuracy, but also just for that very practical reason that you may want to use the work product and have it copyrighted. So one of the tips that I've started to incorporate is when I give an assignment to a virtual assistant or to somebody in my firm, I ask them if they've used, I don't ban them from using AI. In fact, I encourage them to use AI and sometimes suggest prompts that they can use, but I also ask them to keep a record of the prompts that they've used, and also to tell me like what portions they've done through the AI and what portions they've done individually. And so that way you know what the product is, like what the vulnerable points will be, and you also know, if this is going to qualify for copyright protection. The same is true for something like plagiarism, or somebody creating blog content for you. Google doesn't bar users from it doesn't heavily penalize people from using AI to generate blog posts. But if the content is very cookie cutter or very generic, it's still going to be penalized in the search engines. And so you want to be able to evaluate that too. So that's just another thing that you want to keep your eye on when you're working with people or supervising people who are using AI, is to remind them about some of the copyright issues that could arise. And that brings to the duty of supervision. As most lawyers know, and both the ABA and most state bars have some kind of duty of supervision. An attorney is responsible for supervising associates within their firm, also people they outsource to, and that duty of supervision now extends to supervising the actual AI that you're using. So if you have people who are using AI or you're using it yourself, the duty to supervise encompasses verifying the results, checking it for bias, looking at the accuracy, keeping records of prompts and things like that. Another question that comes up frequently that I think is still evolving are disclosure requirements. When the extent to which you have to disclose your use of AI. And so there's a couple of different fora that this issue could come up. There's disclosure to the court and disclosure to your clients. So in terms of disclosure to your clients, it's not a black and white issue. It's potentially a matter of personal choice. The exception in my situation, I like to tell clients that I'm using AI because I want to be perceived as very cutting edge and cool. And so I think it's something they'd like to know. I would certainly love it if I went to an attorney who was using AI, if I went to a doctor who was using AI. It would make me think that they're ahead of the curve and they're really keeping up to date with what's going on in their practice. And also that it's going to give them additional capabilities. The one exception would be is if you're working with a client, like a corporate client, you're acting as an outside counsel to them and they have their own internal AI policies, you may want to find out what kind of information if they have any limitations on the kinds of information that you can be using in a more publicly facing AI tool. Now, of course, if you're working, if you're doing outsourced counsel work for a big corporation, chances are that you're not going to be using ChatGPT for the research. You probably are using some kind of legal tool or tool developed for lawyers that is going to have that kind of protection built into it. There's also confidentiality issues with courts. A lot of courts, unfortunately, are issuing standing orders requiring counsel to certify that, whether or not they used AI to produce something and that they checked the veracity. This issue of inaccurate citations has been a problem for years. The best thing about AI coming on the market is people are actually reading briefs. I mean, it's shocking to me. I will, if I'm responding to somebody's brief, I'll read the cases and they're all wrong. And one of the hallmarks of my brief is I go through every single one. If there's 40 cases, I will put a table together and tell you and put into my table which of those cases is wrong. A lot of attorneys weren't doing that. Now with AI, everybody's reading cases, but because everyone's reading cases, you've got to make sure that that they're accurate. And so when you are using AI for your research and it generates cases, you want, if the court has a standing order requiring disclosure, you want to be able to put that in there. The other thing, I was just going to go back, this is sort of a confidentiality issue, and it goes to, again, the degree of control that you have over the communications. If you are signing a protective order in discovery and you're getting confidential materials in discovery, or if your client is forced to give over confidential materials in discovery, you want to make sure that your NDA is broad enough to state that those confidential or proprietary materials can't be used in sort of a public generative AI platform. And I have seen, it's in the resources, if there's a link here, if I think this has been circulated. If you link to this booklet of frequently asked questions, I link to all of the court orders. And I've noticed that in court orders, at least a couple of recent ones, when they issue a protective order, it has a provision saying these tools, the materials disclosed can't be used on publicly available AI platforms or something along those lines, because that information could somehow become public. So those are just, again, the kind of little things that once you work AI into your workflow, they're mundane problems, but they become issues because you're incorporating something new into your workflow or into your practices. And again, I want to emphasize, we don't need special rules for these things. We don't need to ban use of these things. We just need to keep in mind that they raise new concerns that can be addressed under additional rules and protections that we have. So most of these issues kind of fall under the types of legal ethics rules that will come up. Both Florida was the first jurisdiction to issue guidance on, or to issue ethics rules regarding use of AI. And it has the ones you would think, the duty to supervise, the duty to kind of know what the capabilities of the systems that you use are. They also have a provision that applies to chatbots, and it basically says if you're using a chatbot, you need to disclose to people that's a chatbot, it's not a human, what the limitations are. And it also has another provision saying that you can't misrepresent the scope of what AI can do. So if you're holding yourself out as this AI forward practitioner, you can't misrepresent what that AI is going to be able to do for your clients. And again, do you really need a separate rule for that? No, because you're not supposed to be deceptive in your advertising practices anyway, but that's something that can come up. On that front, one of the issues that I see arising with AI is you've probably seen you may have seen in the last week or two that I think Google released a tool called Lumiere that will use AI to generate really high quality videos from existing pictures. And it occurred to me that you could take a picture of your client and make them, have an AI generated testimonial online. It seems obvious to me that you would have to disclose that that's an AI use. I don't know if that's obvious to all attorneys, but again, it's not something that you have to ban, but it's just something that you keep in mind. If you're going to use AI to generate a testimonial or to generate visuals to explain things on your website, it may be something that you want to just disclose to the public so they don't think there's actually a person doing that when it's a machine.
Hey, Carolyn.
Yeah.
So on that topic, I just wanted to jump in there because it's kind of in our domain of practice of law, and we're sort of talking about lawyer use. One of the topics I've been beating the drum on, and I'd love to sort of get both of you guys' reactions, is the evidentiary implications of deep fakes. I've had a number of judges and conversations with bar associations, and it appears people are sleeping on this. In terms of authenticity of exhibits and evidence, the rise of deep fakes and the presumption now that audio and video are deep fakes, possibly. What is the lawyer's obligation to authenticate evidence that a client may be presenting to him or her that might appear to be real? We're just sort of in this world where that deep fake, and we just saw a horrible thread on Taylor Swift over the last week on Twitter, a number of deep fake videos. This is becoming more and more extravagant, more and more seamless. And I just haven't seen or heard too many people really with their finger on the pulse of that from an evidentiary rules perspective. You guys seeing it or hearing any of that?
So a couple of months ago, I met with a friend of mine who's a federal judge or federal magistrate. And we were talking about generative AI. And one of the first things she said, it used to be when somebody came into court, I assumed that all of the documents that they were presented by somebody, even if they weren't authenticated, there was just an assumption that they hadn't been forged or weren't fabricated. She said it's flipped on its head. Now everything is suspect to her. So because of that, that got me to thinking about what you were saying. And I think that, and it's, it's funny because that's kind of one of the things that in litigation you could always sleep on. Like when somebody was trying, if you'd be in court, say 10 years ago, somebody's trying to lay a foundation, you're kind of like, oh, come on, this is just a waste of time. You're just trying to intimidate the witness. Of course, it's not a forged signature. And I agree that that's something, it's one of those things, again, it's kind of a mundane thing that you become accustomed to relying on one way that kind of flips because of it. So I think it's a big issue, and I don't think people are quite as on it because it's still emerging.
I mean, right now, the first time I saw an example of volley where you could take 3 seconds of someone's recorded voice and then make it say whatever you wanted it to say in their voice, and thinking about implications and things like family law, where, this, my ex left me this voicemail threatening me, blah, 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 or, whatever. I mean, it's going to be used against, I think our defendants are going to be using it against each other. And people are going to have to figure it out. I see now just on social media, this doubt about everything. Is this a real video? Is this a real picture? Is this is AI? And now we have this layer, and I saw Ed Walters talk about AI, I think February 2022. And he said, we've got image, we've got text, we've got voice, and we've got truth. And truth is going to be a big issue. Because as much as I think there's a lot of positive things that are going to come out of this, I think that we're going to have our reality kind of shaken up, and it's going to be harder to tell truth from fiction. And I tell the law students all the time, it's like, this is going to be your job to figure out how this all works now.
Yeah, it's a great point on that. And the other thing I want to just say on this deep fake and evidentiary proceedings is think about the rise of litigation costs, trial costs, right? Just to have the separate evidentiary hearings on this stuff, battle of experts. You think about from self-represented litigants, implications for them too. If they get caught in one of those evidentiary proceedings, it costed completely out of the trial. Or unbeknownst to them, Catherine, to your point, they're relying on something that they believed is truthful that they don't. So now they're bringing, a claim that might not have any merit. And so it's just, I don't have an answer. If I raise a problem, should always have a solution. Sorry, folks. But it's a topic that I'm really urgent about raising out there because it's already in the courts. And I think it's probably in the courts to agree that we don't even realize and the courts don't even realize yet. It's kind of freaky.
I think it will solve itself. We've already seen plagiarization checking tools, AIs that try to determine whether it's plagiarized content or generated by an AI or not. And so I think that, and this was already, I mean, deepfakes aren't new. They're faster and easier, right? So this is something that's been a topic of conversation for quite some time. And you would hope that we would have been a little better prepared for this. If you want to look at some good content, John Simic and Sharon Nelson from Sensei Enterprises Inc. have a lot of great articles about deep fakes and evidence on their website.
Yeah, so that's a big question. So that sort of brings me to the end of this. I mean, on the issue of deep fake too, it's not necessarily related, but because these AI tools are so sophisticated, you could imagine a situation where you could ask and you could develop a video to replicate an accident or create demonstratives that you would present in court. And for litigants who don't have a lot of money and don't have the ability to actually, have professional videographers present those, it could be a tool that could be very powerful. But, if you're on the other side, you would probably want to know how these things are created and what kinds of assumptions went into them. But as threatening as deep fakes are, I also see the power of these tools to be able to, replicate the kind of demonstratives that once upon a time were only available to deep-pocketed litigants. So I hope that there's a way that we work through this. Does anybody, I'm looking at the chat, or maybe we should check the questions too and see if there are any questions, because I'm kind of at the end of the topics that I wanted to cover. I mean, I think the most important takeaway from me is that you've got to use this stuff. I cringe anytime I see somebody saying, let's ban this, let's wait until it's ready for prime time. This is the time that you want to be using this, because you need to know what the problems are with it. Because if you're not using it, somebody else is going to be using it, and you're just going to be caught flat-footed if you don't know what kind of problems can arise from using AI. So this is definitely the time to use it. This is definitely a time to encourage your staff to use it, to train to use it, because like I said, it puts you ahead of the curve, but you also, if you're not using it, you don't know what the issues are with it. And I think, I've been looking at new emerging technologies for a long time. Like back in 2010, I co-authored a book on social media for lawyers. And at that time, most lawyers' attitude towards social media was, that's something my teenager can play with. It's not really something that's relevant to me. And then you would see all these lawyers getting, fooled in court, or not, like looking at somebody's Facebook page to see that this person who was saying they were in serious auto accident was out skiing, or not being able to figure out, that people were communicating behind the scenes. And one of the reasons for that was they just weren't using it. So even though it seems premature, this is really important to be doing.
Yeah, I think the low stakes stuff, and when I say play, I'm not making light of the tools or the work. It's more that it's a kick the tires thing. And if you haven't used anything, I mean, I think the first time I used AI was ChatGPT to write a letter to fire a client. And then the next time I did it to write a dinner menu. I just really started using it for really low risk, didn't really matter, just made my life easier not to have to type this stuff up, or looking at a blank page and kind of being stuck. And so you start realizing, well, this one actually has really good answers and this one doesn't, or if I ask it this way, I get a better answer. You have to use it. Otherwise you are going to be left behind. You don't have to jump in right away trying to get it to write briefs, which we already know is kind of a dangerous game.
Hey,
So-
Carolyn, I see a comment. You might have a resource for this. Kelvin Lee asked a resource for communicating to clients in our attorney-client agreements, what the lawyer may or may not do with generative AI.
Yes. I actually have, so, when the cloud was first introduced, a lot of bar associations said, look, it's okay to use the cloud. You've got to disclose it and get consent from clients. And the bars kind of left it at that. And they never updated their retainer agreements to come up with a template to do that. So I did one for the cloud. And so I have been working on one for AI, because if I don't do it, it's not going to be done. But I'll try to make that available, and I'll update. I circulated a link to kind of a best practices guide that I put together, and I will update it with some clauses for agreements, because it is a good idea. That would be the place that you would want to put it in, is either in your client policies or in an engagement agreement. And I think I know that some big firms have already started incorporating that. But there's also another question about reasonableness of fees and how that's changing with AI. I do a lot of work by flat fee, so it doesn't, it hasn't impacted me so much personally yet. But I think that, if I think that it will have an impact, and I don't know in what form it's going to arise. I don't know if clients will be sophisticated enough to see that their attorney, bills them 2 hours for generating a fancy table that you could put together in 30 seconds with Claude. So I'm not sure how that's going to develop yet. And then there's also a question about plagiarism checkers. Do either of you know one that works well?
The question is, do I know one that works 100% of the time? No. If you want one that works pretty well, Stealth Writer.
Yeah, I'll jump in. I'm putting my law professor hat on in higher ed. Yeah, I'm a part of so many forums for professors that are trying to figure out the plagiarism element here. There isn't a perfect solution. Many professors are coming up with hybrid approaches, or completely redesigning their classes, so it's not even an issue anymore. But the simple answer is not 100%. I wish I had one for you.
That was another great session from LawDroid's first annual AI conference. Thank you so much for watching. Please keep in touch. Subscribe at lawdroidmanifesto.com, where I can keep you updated about the latest developments at the intersection of law and technology, and let you know about great events like this. Keep in touch.